welcome to Legally Speaking with me, Tarun Nangia. Now we commence our part 2 on our topic, which is, does India need a better security regulation framework to protect against misleading reports that would lead to loss of lakhs of crores of rupees of middle-class investors who invest in the stock market? I have with me one of India's top lawyers at the Supreme Court of India and also the Bombay High Court. I want to welcome Senior Advocate Amit Desai. Good to see you, and looking forward to some interesting insights from you on this topic.
It's always a pleasure to be with you, Tarun.
And I want to ask you this, that given in the background of what's happened in India in the past few weeks, do you think that India needs a better security regulations framework to prevent or tackle these kind of sometimes misleading reports? Because this could be a larger case. Tomorrow, people could pre-plan a short selling of a stock, and which in a country like India, where a lot of middle class now invest in the stock market, interest rates are not that high. All of that taken into account, could you give us your analysis of the situation and the problems that an evolving society should solve as it grows?
So, Tarun, I must tell you, before I get into the specifics of your question, I just went down a little bit of memory lane in the context of the events that hit the Indian market in the last couple of weeks. And I still remember that in the early 90s, as we were early days in our legal profession, this whole issue about short selling and how it impacts economies was something that was being debated and discussed even in the early 80s and 90s. And let me give you 3 examples of what happened across the world in the context of short sell, and then come back to obviously the events which have hit India in the last few weeks. So sometime in early 80s, there was a very large, long buy by what were then known as the famous Hunt brothers. They were billionaires from Texas who had been over time going long on silver. And at a given point of time, they had gone long and bought up virtually 3/4 of the world's silver. And then the silver prices crashed, and that's known as the Silver Thursday. And it obviously, because they cornered 3/4 of the world's silver, the impact on societies and the economies of the world, and particularly this was in the US at that time, and of course, 1980s, the economies were obviously much smaller than what they are today. It was a huge, huge issue about how these long buys and short sells happen. So that was one event which took place. It resulted in a lot of SEC inquiries, SEC fines. Ultimately, they were fined by the SEC in relation to these particular transactions. The Hunt brothers went into bankruptcy and all kinds of problems occurred. But it was an interesting issue about a long buy of silver. The next thing that came to my mind was sometime in 92, 93, one of the most famous hedge fund operators in the world today, a gentleman by the name George Soros. He became famous because in 93, he bet against the Bank of England. So he bet against the pound. So he went short on the pound because he saw a certain economic event that was happening. And the Bank of England in those days, London and UK, was in a recessionary trend. And John Major was the prime minister at that time, and he actually wanted to show that the UK economy was doing well. George Soros bet against the pound. And ultimately, the Bank of England had to succumb. So the Bank of England suffered £3.5 billion loss. George Soros made his famous $1 billion profit, and many other short sellers of the pound who had by that time started gathering around also made a lot of money. What did England do about it? They didn't change the laws at that time, but because of the impact of this particular event, the interest rates in the country went up. And there was a serious impact on the economy of England at that point of time. It's an interesting sort of story to tell. But a few years later, and this is again in folklore, the same gentleman, George Soros, decided to bet against a basket of currencies in Southeast Asia, so Indonesia, Thailand, Malaysia. And it is rumored, and so our articles are there, that his actions were the precursor to what was known as the Asian flu, when these economies went into a recession because of the conditions that transpired at that point of time. Interestingly, Malaysia brought in capital control at that point of time to try and prevent these kind of activities again. I mean, I'm just putting context to how short sell or long buys have significant impact on economies apart from individual transactions or individual organizations, etc. Now, short sell or long buy is essential in every financial system. Has been around for centuries, so you can't do away with it. It's integral to the financial system of a country because it helps price discovery, be it commodities, whether it's crude, you take all the commodities markets across the world, they live on these kind of short sales and long buys. So when you talk about the general concept here, I think you can't do away with that concept. The question that you rightly raise is that in the context of what is otherwise a necessary and a legitimate activity, is that where is the scope for what we may want to call as a market abuse? And it is that market abuse or the market manipulation which needs to be captured by regulation and by governments. And I would say more so in today's economy and more so in today's world, where the level of integration globally is far greater. And everything that's happening is through the internet, and you're looking at cyber crimes across the planet. You're looking at and talking about cyber wars that can happen as we go by, that how does a country start protecting itself? This short sale is an example of what could be the future implications of something as big or even bigger for an economy of a country. And therefore, you rightly ask the question that do we need to do something to protect it? I must tell you that I think the government has been cognizant about these problems. And I see that in the context of two changes. One I saw in the provisions of the Banking Regulation Act. So sometime in 2006, they introduced a provision where they gave a power to the Reserve Bank of India that in relation to money market instruments, which are actually critical to protecting the economy of a nation, and possibly in recognizing the events which had happened in the 90s and etc., they conferred powers on the Reserve Bank to issue regulations in relation to money market instruments, derivatives, dealings, etc., where they believe that there's a potential for an abuse to protect the economy. And that power is with the Reserve Bank of India. So these are those kind of sort of instruments which impact the economy where the RBI has control over it. So this is one provision which is there, of course, hardly been used till now because we've never had an occasion of that particular type. But there is a provision in the Banking Regulation Act. Taking us to the securities market, if you look at the scheme under the securities market, I think there are provisions which are already there. So the question today is about how to make it a little more robust. But let me give you an example of some of the provisions. Take these offshore derivatives. And today we are talking about it because we've read about in the context of the event of the Hindenburg report that there were offshore derivatives which they call non-traded, non-India traded offshore derivatives which are supposed to have been acquired and resulted in some of these activities. Offshore derivatives are actually contemplated by the FPI regulations of the SEBI. So there's a whole scheme where the SEBI has already provided that those who are trading in offshore derivatives, there are a category of people who are entitled to trade in them. They are the ones who are supposed to register. And there's a whole process that the SEBI has provided for in relation to the registration of these FPIs who are entitled to deal in offshore derivatives so that they have some understanding in the marketplace as to what's happening. So SEBI tries to keep control over that. Now, question is, in the context of the events which have happened, as SEBI would go into it in greater detail, did they miss out on some aspect of these offshore derivatives? And do we therefore need to improve the regulation, make it more robust so that despite the fact that the SEBI has some basic regulation in place, you need to strengthen it so that these kind of offshore derivatives which are used where the underlying assets are in India, in this regulator is able to anticipate and capture the implications of these offshore derivatives on a market in India. Having said that, let me take you to two other regulations that are also there in place in India. One is the FUTP, which is the Fraudulent and Unfair Trade Practices Regulation, and the second is the Insider Trade Regulation. The FUTP actually deals with manipulative trades. And there will be a question that will arise as to when does a trade become manipulative within the definition of the FUTP. It's a very wide definition, extremely wide definition. And therefore, there's a fair amount of discretion with the SEBI to look at the underlying facts, assess whether in a given case, a short seller or long buy actually is a transaction not for the underlying purposes for which you allow a short sale. Because today, I must tell you, today the derivatives market is what rules the Indian stock markets. Probably about 95% of the trades in the market are derivatives. All these are all in that sense short or long. Now, if part of those trades are going to be in the nature of market abuse, then obviously you have to capture it. As SEBI has a wide definition of under the FUTP of what is a manipulative transaction. And therefore, they could then go into the question as to whether these kind of trades, where you talked about misleading reports, are actually a short sale you've acquired these derivatives earlier, and then you want to talk down the market so that you can then profit from the transaction that you've already undertaken. And therefore, if there are misleading reports which are an attempt to talk down the market, then whether that would constitute an FUTP violation. Similarly, in the context of insider trading, because an insider definition is also fairly wide. So there'll be a deep question that when you have a person who is actually trading in the securities and dealing in derivatives is a trading in securities under the definition under the insider trading regulation, that person is got in his possession a document which he is going to release at a point of time into the marketplace, which nobody else knows. Now that decision to release at a given point of time could be treated as a price sensitive information. Now, if he's treated as a price-sensitive information and he's the only one who knows that it's going to happen, then he is actually possibly within the domain of the insider trading regulation also. And these are matters which obviously the regulator will have to know. Now, where does this take us? Because you're dealing with a situation where here is a foreign participant who is sitting far away and playing on the Indian market. And the question is, what is the reach of SEBI to such participants who are outside of India? Because if they were in India, obviously it was very easy to say that we will catch them within the jurisdiction in India. There are challenges of the outreach that SEBI may have. It's an interesting judgment of the Supreme Court in Pan Asia, where a question that came up was in relation to an FUTP matter of a GDR. Now, a GDR is obviously listed outside India, but the underlying asset was in India. And the question that came up was, does SEBI have jurisdiction to go into the FUTP transaction on the GDR, which was listed on an overseas exchange, though the underlying asset was in India, in the impact of it was felt in India. The Supreme Court has held that SEBI has the power to legislate in relation to any matter where there is a close connection with India and the impact is felt in India. Therefore, SEBI has been conferred, if one may call it an extraterritorial jurisdiction, actually it is territorial because the impact is in India. The consequence of India, as you rightly said, the middle class of India are the ones who are suffering the consequences of this action. So Supreme Court says you have the power to legislate, and have held that these kind of transactions which have happened in the international market where the underlying securities in India, SEBI has jurisdiction. So in that sense, we have the issue of SEBI. But what happens if these people who are outside India do not submit themselves to the jurisdiction of India? How do you deal with that part of the problem? So you have an organization which is in America, which has done this transaction. SEBI will issue a show cause notice. They will say, we want to disgorge the profits. They're sitting far away in America. They might say that, sorry, I'm not submitting to Indian jurisdiction. Now, this is where there possibly is a need to start strengthening the relationships between Indian regulators and the overseas regulators, be it in all these countries where they have registrations, where they have residing, and then determine that is there a way by which, through means of cooperation between the SEBI and the SEC or the UK authorities or the European authorities or wherever else it may be happening, that these people who are creating a market abuse in territories and countries outside of their own, there should be the ability to take action against them. So I think one of the areas where we need to look at is how do you strengthen the international relationships between the regulators to ensure that there is a process by which they can reach out to those who are perpetrating market abuse in different jurisdictions across the world. Because this is necessary, just like you have the OECD, which is trying to protect the economic interest of all countries. This is something which needs to be looked at because ultimately these are interconnected markets. Today, we are raising capital from America. We are raising capital from the rest of the world. Our capital is flowing into those jurisdictions. So there is a lot of exchange of capital that's happening. But all these markets need to be protected. So can it be that somebody sitting far away can impact the Indian market? So this is where one area where I think the SEBI possibly needs to strengthen its relationships and find that there should be treaty arrangements between these countries where they can actually reach out in relation to the market abuses that are happening across. So this is one other. The other area where you possibly need a strengthening, interestingly, the SEBI and the NSE has what is known as a surveillance mechanism. So the advanced surveillance mechanism which they have, which is really to try and keep the market stable. So they see the volatility in the market to try and protect the markets. They put in filters, they put in, like it did happen recently, as we know about. The question is that did they have enough data and do data analytics to anticipate such a serious contagion, if I may call that, over a period of time? And if they didn't, then is there a way by which they can improve the data collection, maybe by issuing further regulations and ensuring that this surveillance mechanism is further strengthened, so they have the ability to anticipate that if somebody has taken an exceptionally large bet, which is disproportionate to the market itself, then they might be in a position to come in at an earlier stage and protect the market by putting in adequate filters or surveillance mechanisms so that the market doesn't actually crash. So this is the other part of it.
Thank you. Yes.
Yes. No, I just thought I'll complete one more aspect, unless you have another question, and I'll then bring in the criminal law aspect to this whole thing.
Yes.
Let me tell you that these regulations under the SEBI Act, they're also subject to prosecutions. It's a prosecutable offense. Now, in relation to a prosecutable offense, if they find that a crime has been committed, then SEBI has the authority to go and file a prosecution. Now, if there are people outside India, it is very common, we have seen in the last so many years, for applying for extradition. So in the criminal law jurisprudence, there's a potential to secure a person who has committed an offense in India and seek his extradition from outside India. But in the civil law jurisdiction, we have some weakness, if I might say, and the need to actually go about and strengthen that particular part of the process. So these are, I think, there is something where you need to strengthen, but I think we have a fair amount of material already here.
Thank you, Mr. Desai, for sharing in detail and giving us an insight into what has happened, what can be done, and with what areas of law we need to focus on. Appreciate you joining us, and thank you so very much for your time. So now we are joined by Malak Bhatt, advocate, who's a founder and senior partner at NM Law Chambers. Good to see you, Mr. Bhatt, and looking forward to some interesting insights, like always.
Thanks, Tarun.
And at this point today, we are discussing this very important topic of, does India need a better securities regulation framework to prevent against misleading reports like the ones that we've seen in the recent times, which may cause the savings of millions of middle-class Indians to wipe out. And it can have an economic impact whose, in a sense, effects will last far longer than the immediate impact itself, because this involves savings of people. I will leave it to you to explain what you think of this issue and how should this be seen.
Sure. Thanks, first of all. I think let's first look at the way the Supreme Court dealt with it yesterday. I think that itself was a very encouraging move that the Supreme Court took over, where Justice Chandrachud, Justice Narasimha, and Justice Pardiwala, in fact, spoke through the medium of the middle class of the country, that do we really have a robust system at present to tackle situations like this, where the market sentiment gets either dwindled or the investor of the country today is facing a financial irregularity or a financial crunch because of information that's in the market. So in fact, that was a very encouraging move by the Supreme Court itself to bring this forth and say that, look, what we need to really protect is the middle class investor sentiment, which today controls the almost $5 trillion economy that we have. But largely what is at scope, and I'll break this up in three parts, is number one, is the current regulatory mechanism sufficient or robust enough to tackle this at two stages? One, is it able to deal with it at the preventive stage? And second, do we have this at the course corrective measure at the right timing? In fact, in the first part, Mr. Rohan Shah really touched upon this very well, that what is required is a immediate and prompt solution, because once the information is out in the public, in the market, to actually take a course corrective step, if the time lag is a lot, by this time the information, especially a misleading, false or untrue information, can cause so much of damage that it may not be able to course correct. In that regard, if you see the current framework, yes, as far as information concerning public listed companies is concerned, SEBI definitely has a lot of measures in place. It as a statutory body has a lot of powers to itself. So if you see, in fact, there are various advisories that the SEBI comes in from time to time. So the latest Master Circular of 2021 actually has a direction given to all market intermediaries, which include every intermediary coming in the ambit of the SEBI, be it a depository participant, be it a trader, a stockbroker, a merchant banker, to have an internal code to check market sensitive information at the very beginning. So in that regard, it is kind of a preventive action that, look, before you disseminate any information regarding a listed company in the market, you do need to have at least some fact finding done, so that the information is not either misleading or untrue to actually affect the security market or the capital market today. But the limited scope of that, and that in fact is coupled with their own powers, SEBI's own powers under the Unfair Trade Practices and Fraud Regulations of 2003, where they cover that any person who comes within their regulatory powers will be heavily penalized. In fact, the penalties to the tune of almost 20 crores if the information that they disseminate is in the nature which causes a securities fraud. And that obviously includes information which is misleading. But the problem with that framework today is, Tarun, that SEBI's own powers are limited only to the entities which are covered within its own ambit. What today we are faced with is a information technology savvy world, an economy where 622 million users are internet friendly. The middle class is completely savvy with social media and internet framework. So this, at that stage, will probably require the hands of other agencies as well. And that in fact was a very interesting observation that Justice Chandrachud brought in yesterday, that if we do set up a panel to look into this, obviously SEBI will be part of it. Will we also need stakeholders from other agencies, other ministries, entities, etc., to actually also come in the fray? And let me take a cue from that and actually see how this actually works in the other countries. So if you look at the US or the UK, so UK parallelly is very similar to us, but the UK, in fact, for the longest time under the Securities Exchange and the Securities Exchange Commission Act and the Securities Act of 1934 had very similar provisions to us, that they had a preventive task of checking information only at the stage of entities which are governed by the SEC. But lately, because of the advent of technology, information spreading through mass media, etc., the course correction that they have brought in place is actually twofold. So if you see the Sarbanes-Oxley Act, or if you see the Dodd-Frank Wall Street Act of 2010, which in fact was the biggest revelation of Barack Obama, they have brought in consumer protection as the guard to control fair trade, to control market regulations, corporate governance, which includes misleading information. So they, to that extent, have called this a pre-vetting of information relating to listed companies before it can go out. So one, it's preventive, and two, it is also deterrent, because the person who disseminates the information, if the information knowingly is wrong, can actually amount to either a corporate fraud or whatever his necessary licenses in his own field of regulation are, can be revoked or cancelled by the government. So these are the kind of issues which US has already tackled with. Interestingly, in fact, taking cue from US, Dubai recently has also brought in a very wide amendment. So the DFSA, the Dubai Financial and Regulatory Services Authority, has now covered within its ambit any person who can be liable for a market manipulation or manipulative information through the market, when the person knows that the information is false, untrue, or misleading. It's not restricted only to market players. And probably that's where we will also have to rethink that, do we either need a specific law or a new regime which can deal with information dissemination regarding all public listed companies, at the preventive stage of checking it before it reaches the market, or some immediate mechanism in which it can either be taken out, or the authority, be it SEBI or whoever, can course correct and say, look, this information was wrong. Is there a way I can deter the loss which has already occurred and recoup the market loss that the public today faces?
Thank you. Thank you for explaining, Malak, this so in a detailed manner, also giving a comparative study of what happens in other jurisdictions, and appreciate you joining us. The issue is not ended, so maybe want to invite you again to discuss this more as the situation evolves. But indeed, I think this is one such situation that we had not seen before and which we are witnessing today. And I think that's how laws will also evolve. Appreciate you joining us.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.